Great to be here once again. Thank you to CSIS for allowing us to put on this program, which promises to be a very interesting conversation with a good friend of mine, Dr. Jim Edwards. Jim Edwards is the founder and CEO of Elite Strategic Services, where he consults on intellectual property matters, antitrust, and other issues. He has long been involved in policy issues in Washington, D.C. and around the United States. He worked in Congress for multiple members, a senator and a couple of congresspeople over a good number of years, working his way up from the very entry levels all the way up on the staff of some of those members. But for quite some time, he has become an expert in intellectual property law and policy. In 2017, the Eagle Forum Education Foundation recognized Jim with their annual Eagle Award, high praise, and that's just only one of several recognitions for Jim Edwards. I'm honored to be with you here today. Welcome, Jim.
Thank you, Andrei. It's great to be with you, and I appreciate your doing this for me. It's great to be able to share something with the world because of your generosity.
Well, we are here because you wrote a book called "To Invent is Divine." And the book was just released. It's a fascinating book, and we're here to discuss that. So let's start at a very high level, and maybe you can tell us a little bit about the book. What are the main points? What's the main thesis of your book?
Well, it takes a scriptural orientation and framework, Judeo-Christian scripture, and looks at what is in there that relates to patents and invention. Because that's what the question was to me initially was, could you give a speech at my church on patents and invention, but from a biblical point of view? So that kind of got me started on this road. And so what I do is look at creativity and ownership. And it's clear, God, he claims everything that he created as his property. He endows in us, human beings who are made in his image, with those same communicable attributes, creativity and inherent ownership to the things we make or the things we grow or the things we build. So it's creativity plus ownership connected are mutually reinforcing and produce human flourishing. That's the thesis of the book.
And we'll get into all of that. In fact, on the cover of your book, it says creativity and ownership. Obviously, they go hand in hand. So I want to get into all of that, but let's step back. So the United States is founded in 1776. Constitution is ratified, and the Constitution itself mentions intellectual property rights, right?
Yes.
And obviously, the founders were religious people back in the day. But are your concepts? Do you find your concepts in the Constitution itself and what the founders put in there?
Yes, my contention in the book "To Invent is Divine" is that the founding generation, they came at a time when previously, like the early and mid 18th century, was this tremendous, extensive, impactful across the colonies religious revival. And there were people like Jonathan Edwards and George Whitefield preaching the gospel up and down the Atlantic corridor. And so everybody at that time was influenced and understood more and heard these sermons, and it was great interest generated in the Bible and in Christianity and in what they are to do and who they are as human beings in light of God and all that He has done for us. And so what happened was the influence of the Great Awakening, the first Great Awakening from like 1740s and 50s, continued. So they grew up the Founding Fathers grew up in a Christian, Judeo-Christian community in which the Bible, Scripture was a prominent book in everyone's home or most people's home. If they had no other books, they probably had a Bible. But if they had multiple books, that was certainly among them. And so it was a Christian society. It was biblically steeped. And so the Founding Fathers knew and understood what the Bible taught, and including God on the first day created the heavens and the earth. And then you get Psalm 24 and verses like that where it says, the earth is the Lord's and then the fullness thereof. He's outright claiming to own everything He makes. And then you start looking at the teachings from Scripture starting in Genesis and the Garden of Eden, and Adam before he was he fell and ate the apple. He was even then told by God he was charged to work and keep the garden, care for the creation. You're responsible for this, and I want you to make things out of what you have here. And so it's that work, human labor is a good thing, because this was something that God ordered before the fall, and it's something that He ordered and gives generally to apply to all of humanity. Our basic situation is poverty. We have to work to get out of poverty, and we have to work to stay out of poverty. That's the human condition absent work. So work has dignity. It's honorable, and that's the sense in which creativity and ownership were known to the founders. They knew it from Scripture, and they knew it from others such as John Locke.
So let's talk about John Locke and Lockean principles here, because it's one thing to say that you have to work as a human being to get out of poverty, which clearly is the human experience, and there is dignity in the work. It's a different thing. It's another step you have to take to reach the conclusion that you are entitled to the fruits of that labor that you're putting in. And it's not necessarily a given that people have that understanding or have had that understanding all along. It took the Renaissance, at least in the modern era, to bring Locke and his compatriots at that time, thought compatriots at the time, to say that humans, there is a benefit from humans owning the fruits of their labor. And is that rooted in biblical tradition as well, in your opinion?
It certainly is, and not only in my opinion. A friend of mine, professor at American University, Daniel Dreisbach, has a book called Reading the Bible with the Founders, or the Founding Fathers, I can't remember. But one of my favorite things in there, and I incorporate into Invent is Divine, is the metaphor that's found several spots throughout Scripture, and that is the vine and the fig tree metaphor. And this is the fruits of your labor. This is enjoying the fruits of your labor. It's something that talks about the owner of the vineyard sits at the end of the day working. He sits and enjoys the fruits of those plants, the vine and the fig tree, in peace and rest. So it's a very calm, secure setting. It's not because of they're stealing somebody else's property, and it's not because it's because they're at rest and at peace because no one is taking their property from them. They're able to enjoy in assurance that this is their property.
And there's no question in my mind that the United States is founded on this principle. And I just want to spend one more minute on this, because it is definitely not a given that that is the way society should be organized. Just to be very simplistic about it, it could very well be that society is organized that you put in your labor and then everybody else has immediate access to the fruits of that labor. And famously, from Marx and Engels, everybody works according to his abilities and everybody consumes according to their needs. That's a different way of organizing human society. The United States, with its founding generation, they picked it seems like they picked the Lockean point of view, which you're saying traces back to the Judeo-Christian principles.
Yes, exactly. It was Locke who kind of put it in non-religious terms, but it's the same teaching of the thing that's interesting about the vine and fig tree metaphor is that how frequently it was invoked and incorporated into the writings of the founders. So George Washington used it extensively, and so did many others of the founders. But it's something that really resonated and represented all that they knew also from Locke of you improve property that's found in nature, it's yours. And that is the fruits of your labor. And that's something you're due inherently.
And let's now extend that thought to intellectual property, okay? So in the Constitution, as we said, the founders provided for intellectual property rights in Article 1, Section 8, Clause 8, where it says that Congress can give, quote, exclusive rights to authors and inventors for their respective writings and discoveries, effectively the foundational statement of the copyright and the patent system. And first of all, to note, the word right is in that clause, and is the only place where the word right appears in the Constitution, right?
Yes, other than the Bill of Rights,
Right.
which came later.
Which came later, right. So they definitely saw that as a right, and not just a right, it's the exclusive right to that creator. So they saw that right, at the end of the 18th century. So translate, if you would, so they clearly had Lockean principles in mind, but translate, if you would, how you get from the Lockean principle of improving your land, and therefore you get to eat the fruit of the vine, or you control the fruit of the vine, and you can sell it, I presume. Translate that into intellectual property rights and the constitutional grant for that.
Well, if you grow something, you're a farmer, you're a vintner, whatever, you grow something and you get the literal fruits, then you are able to do with those fruits what you wish. You can consume them, you can sell them, you can trade them, you can stomp on them and make wine, you can do many things with it. That's your prerogative, and that's another akin to another biblical metaphor of the potter and the clay. And there are several instances in Scripture where that occurs, but the point is the potter is the one who decides what to make, how to make it, what shape, what use will it be put to. Do I want to, before I finish making it, start over with this clump of clay? That's his prerogative as well. But the potter is the boss. The potter makes and fashions and uses that or sells it or whatever, that product that he's made, and it's totally up to the owner. And so how that translates into intellectual property is that we're talking here about something that's property that did not previously exist. The farmer started with something, right? The seed, the plant, it's in its early stages.
The land, for sure.
The land, all that. So, and just puts the work into it to keep, to use the language, that area to produce fruit or vegetables or whatever. But intellectual property it's a human creation. Now, God's the only one who can create ex nihilo out of nothing. We can't do that, unfortunately, but he didn't share that. But we can make plenty of things out of nature. We find, whether it's a mineral, whether it's a molecule, multiple things we can improve. We can make changes to make them something useful for human beings or enjoyable for human beings. So whether you're talking about new ideas that are copyrighted or in a book or in music or anything, then you're also talking about the useful arts and the practical machine or other type of invention that you have to have some way of differentiating and assuring that invention is novel, that it's new, it's something that's different from anything else. Basically, you're creating new property, and the patent office is discerning the boundaries, the metes and bounds of the property lines. So,
well, if, as you said, if you have a farmer that's growing literal fruit, they own the land, but at a minimum, the land was there. It's part of the earth. It's there from time immemorial. The farmer either owns the land, they bought it from somebody, or they rent the land, whatever it is, but begins with the land and creates fruit that's just out there now. And the concept, Lockean concept here, is that the fruit belongs to those who worked to get it produced by the land.
yes.
What's interesting about intellectual property, because you've just said it, and I just want to crystallize it a little bit, is that it's that concept on steroids to some extent.
Mm-hmm.
Because you don't even have the land in this example. Obviously, you have materials and natural resources that might exist out there, but there is no land necessarily that you begin with. You begin with effectively nothing, just an idea in your head that didn't exist at all. Theoretically, anyway, if you're the first one to have done it, it did not exist at all before it came into your head. So now you've created it, you've created the idea, the new machine, process, whatever it is. And by definition, it belongs to you. It's not even, it's so much more than just the fruit, because the fruit, the tree is out there, people theoretically could come and grab it. If you don't let it out of your head, it's clearly just in there. It's the most human possible, the most human articulation of what the human being is. An idea that's in your head, by definition, cannot exist anywhere else. It doesn't even exist in nature. It doesn't exist in anybody else's head. It's just in there, and nobody else can have it physically. It's just, unless you give it out physically, it's only inside you, just like your heart is inside you or your lungs.
Yes, and the beauty of it is, if you turn that into something that is, it works, it's useful, it's practical, it's new, then you can have protection for it with a little deed called a patent, And you can also not patent it and keep it, that idea you've worked out into something practical. You use that as a trade secret, but it's still your property, and it's still it's the what you've built around your idea, the bringing forth into some manifest form the idea into something.
So this is where intellectual property rights come into play. And I want to read something to you in a minute, but in order, so naturally they are just inside you, therefore they belong only to you. It's by definition. Nobody can get them out of you unless you give it out. This is where intellectual property rights come into play. The Founding Fathers recognized that this is the situation. Creators, first of all, they have to be incentivized to go actually put the work in.
Yes.
And work the land, so to speak, work the creativity land and come up with stuff. But then the next step is to coax them to get their ideas out into the public domain. And for that, they saw early on that you need the rule of law.
Yes. And the interesting thing about Clause 8 of the Constitution is that the founders put a purpose statement at the beginning of Clause 8 for the progress of science and useful arts, and then it says that's why, but Congress may make this law to secure, and that's the word, secure exclusive rights to inventors and writers to their discoveries and writings. So it's an exclusive right for a limited time, but that period of exclusivity is meant to incentivize you to bring your invention and the knowledge about it forth. So that's the patent bargain, so that immediately the public gets the learnings of that invention, while the patent owner, inventor, gets to keep and use, commercialize, benefit from, create wealth from, build a company around that invention. And that's what it is, the ownership part.
And why did you focus on the word secure? Why did you say that secure is the key word there in the Constitution?
Secure is the key word, because this isn't the government granting somebody rights. They have the rights by God. They're inherent. They're by being human beings and making something, they own what they make. That's clear from Scripture, Locke, on down the line.
And that is such an interesting observation. And by the way, very few people have that observation, but it is such a key point that the word secure is in Article 1, Section 8, Clause 8. It is precisely goes to that point. The government does not create these rights. Government doesn't just give you the rights or grant you the rights. So to those that argue that patents or copyrights, for that matter,
yes,
are government grants, that is not the way the founders saw it. They're securing for you a right that already exists in you. It's a natural right. And do you know how we know that? All you have to do is cross-reference to the Declaration of Independence that came just a few years earlier. And you know the famous line at the very beginning of the Declaration of Independence, where it says that we hold these truths to be self-evident, right? Again, the natural rights that they recognized, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, famous lines. And here's the key: that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Those natural rights, life, liberty, and the pursuit of happiness, are not given to you by the government. They are natural rights that the Creator, in the Declaration says, the Creator has endowed to human beings, life, liberty, and the pursuit of happiness. And all that the government does through the rule of law is to protect them, to secure them.
And the interesting thing is that securing the rights that are inherently yours already, whether the government recognizes those rights or not, the fact is you are the one who has those rights. The government has no just cause for alienating those rights from you. You have to be consensual to giving up your rights. And you can do that. You can sign a contract for employment to go to work at this big R&D company, and I'm going to assign my rights to any forthcoming inventions and writings, blah, 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 to the company. My name will be on the patent or trademark or whatever, but it's still, you are voluntarily, willingly alienating your rights to some degree. But that's different when it's consensual than the government taking it from you. That the thing that the founders knew was that you cannot have the progress of science and useful arts in a meaningful way unless you keep creativity and ownership connected. The minute you break them apart, you disassociate them, you divide them from one another, that's when you're off on the wrong track. And governments can and do that around the world over time for many years, but that the outcome is always the same. If you have strong property rights, including intellectual property, then you have progress, you have economic growth, you have wealth creation, you have human flourishing. If you take those rights away, those outcomes go away.
So in your book, you spend a good part of it, at least at the beginning, chronicling your findings and research as to the evidence that that your thoughts and everything we've discussed, your creations, are yours, endowed by the Creator. We talked a bit about the Constitution, where it seems like that is, from the Declaration of Independence through the constitutional grant, that's where the founders were. Do you want to spend a minute to talk a bit more about what other pieces of evidence do you have to think that these actually are endowed by the Creator?
Well, because I found the same themes of God's creating and claiming ownership to what He has created from Genesis to Revelation. It pops up in parenthetical phrases that, throughout the Bible, you will find a parenthetical throwaway clause there of that, we do blah, 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 worship, glorify God, parentheses, who created the heavens and the earth, comma, proceeds with whatever the rest of the thought is. But it's in there, just as a given because it is true. And then the ownership part is the same thing, and owning what one creates. God does that, but He also endows us, as the founders put in the, captured the same essential thought in the Declaration that you cited. God endowed these communicable attributes, including creativity and ownership. Our rationality sets us apart from other creatures. So there is ample evidence in Scripture. One thing that I think I mentioned both the potter and the clay and the as the ownership metaphor, and then it's creativity and ownership in the vine and fig tree metaphor. I mean, it's you do the work, you get the benefit, and you enjoy it, and those rights are secure. You're resting in the shade at the end of the day, enjoying the fruits of your labor, literally in that case, and you're at peace though. There's no threat to the taking of your property.
But the very beginning of that whole process is the creativity itself.
Yes.
No other animal has it,
Exactly.
really. Certainly not to the extent anywhere close to what human beings have. So clearly, creativity, whether it's technical, therefore on the patent side, or artistic on the copyright side, whatever it might be, creativity clearly is a uniquely human experience, and perhaps that's what Scripture recognizes.
Yes, exactly. That is it. And it's brought to bear throughout history by both Christians and non-Christians. One other element that's interesting, and it's a facet of what you're driving at, is the doctrine of common grace. That is, there are things that God provides to bless humanity regardless of the individual's standing with God. Some are devoutly religious and believe and seek to serve God. Others don't believe in Him. Others, don't know, and others, shake their fist at Him. Just reject any notion of God in a fairly strong manner. But regardless of their standing with God, they get blessings. They get the benefits of their fellow human beings' creations. They get the benefit of the movie that makes them cry. They get the benefit of the medicine that saves their life or improves their health. They get the benefit of multiple creators and inventors' works. We all enjoy multiple things multiple times a day, and we don't even give it any thought. But that is human flourishing, that output of creativity, and it works best when it's creativity connected with ownership. But the common grace factor and the examples given in Scripture are like the rain. God sends the rain to fall on both the evil and the good. That's pretty clear example that we all have benefits. The rain to enable us to grow our plants or those things, or to nourish us with the water we need. It's an amazing thought that this human flourishing, this creative ability He's endowed us with, is something that improves the human condition. That's how it happens, by inventors, by creators.
Yeah. Whether, and you may or may not agree with what I'm about to say, but whether you believe that it's the creativity in human beings is endowed by God or by simply nature or just the way human beings are, it's clearly undeniable that creativity is a uniquely human attribute, and in fact, the primary attribute that distinguishes human beings from the rest of the animal kingdom. And once there is a recognition that this is the natural state of human beings, is to create, the next question goes to ownership. And I think this is a very important point. And it wasn't, the state of the human condition and innovation, the rate of innovation was certainly not anywhere close to what we're used to today until the founding of this country.
Yes.
And look, human beings have been around for a long time as human beings with this natural or God-given attribute of creativity, but still, despite of thousands or tens of thousands of years on this planet, or hundreds of thousands, whatever the number is, a very long time, still the state of the human condition in 1776 was not very different than it was in the year 0 or in year 5,000 before Christ. So something happened when our founders married this concept of creativity with ownership through the intellectual property laws that created this unbelievable and unprecedented boom in creativity. What is that? Well, what was that turning point and why?
Well, my contention is that the American patent system, especially the first couple of hundred years, has embodied the biblical framework for human flourishing that I've described better than any other patent system. I mean, previously you had patents, but they were granted to cronies by elites, by royals. The king would grant his buddies, I'm from South Carolina, and the Lord's proprietor got the patent, the land patent, to create the Carolinas, to settle the Carolinas, to make it into something, and that's that was Charles II giving granting this right, this access to people who were supportive of him, because previously there had been this displacement of the what's the name of that line of British royalty? I can't remember the Stuarts, maybe, I think. Yeah, the Stuarts. So they were out for a while when Cromwell was in, and then things changed back. So he's rewarding his buddies. Lord Ashley Cooper was one of the supporters of the royals, and Charles II in particular. But you get the kinds of democratization as well in our patent system. You get the democratization so that the patent is granted in America starting with 1790, with the Patent Act of 1790, then same thing with Patent Act of 1793. All of them say, who gets this patent? The first and true inventor. First and true inventor. The first person to invent it's the one this is rightfully their property. So that's what the Patent Office, or whoever the examiners, be it initially.
Thomas Jefferson in the first instance.
He was one of those, and it was the cabinet secretaries, 3 or 4 cabinet secretaries, who once a month would examine patents. So it was a backlog, let's just say, on patent grants.
But that is just, so to emphasize that point, it's a turning point in history.
Yes.
This particular point but it's not. It is in the Patent Act of 1790 and 1793. Just to remember for the record here, the Declaration of Independence is 1776, but the first George Washington takes office in early 1790. The government gets established in 1790. So, I think the 4th law passed by the first Congress is the Patent Act.
It was one of the first several.
Very early. So definitely it's...
2nd, 3rd, 4th, something like that.
It's in there. And then George Washington quickly signs the first patent in the summer of 1790. By the way, do you know what it was for? The first patent?
Potash.
Potash, fertilizer, yeah. Very apropos of an agrarian society at the time. But it's also, it's in the Constitution itself where they recognize, really for the first time in a government's history, that the exclusive rights go to the author and or the inventor. Yes. For their respective writings and discoveries. It's this marriage from the Constitution itself. It doesn't go to somebody else. It doesn't go to the person who's friends with the crown. It doesn't go to the person who has the most money or the biggest factories. It goes to the specific author and the specific inventor who came up with that creativity. That's a major turning point.
Yes, it is. The democratization and the making sure they're ascertaining who that is. And my friend Phoebe Miles, whose father was an inventor of Gatorade, says that those patents had to be signed if it was the wife who didn't have the right to vote, but if she invented something, she's the one who had to sign the patent. It couldn't be signed by the husband. And so there's a real democratization that empowered every American and incentivized every American who had any kind of abilities, creative or technological abilities, to bring them forth and bring them to bear on trying to advance the United States pretty quickly out of the shadow of the more well-endowed former mother country.
Mm-hmm. So, and that is because the founders recognized that the rights naturally are created by the creators, and that the rule of law, government, simply secures those rights. In other words, gives them ownership to their own creativity, and that is clearly outlined in the Constitution and in the first Patent Acts, and then it's carried forward.
And the Patent Act of 1836 is really where it came. The first act, it was too slow, 1790. You're asking cabinet officers to examine patents, and they're really stressed for time. And then 1793, it just kind of threw it open, not much examination, and there was allowing more patents and let the courts sort out the disputes.
Yeah.
And then you get 1836, and it's a bit more of a balance. It's more professionalized. There's a more qualified examination corps. There's a building built over on F and Ninth Streets that for 90 years was the home to the Patent Office. And you had patent models. And from the beginning, I mean, that was at the Federal Hall in New York, the first location of the U.S. Capitol, or seat of government, rather. But that is something that we made a point of, was to have patent models and drafts and things of that sort made to get that initial information to the public so others can invent around that invention while it's under patent. But then, at the end of the day, the patent expires at a certain point, end of the term, then everybody can use that same formerly patent-protected invention for their own use.
So in the book, you give one of the things I enjoyed most about the book is that you give a lot of examples of great American inventors throughout history. So what happened after the modern patent system was established, as we've discussed, creativity blossomed in the United States and has taken off. It hasn't stopped since. In fact, it keeps accelerating by the day, as we all know. But talk a little bit about some of the examples you give in the book. There are some great examples. I don't want to preempt them. So you pick a couple of that stand out to you most.
Well, let me attribute the inspiration for the abundance of mentions and anecdotes and stories of inventors of all, well known or not, is to you, because as U.S. Patent and Trademark Office Director, I think every speech or comments or recommendation or remarks I ever heard you give, you always had some inventor story. And that struck me as important to do, because that brings it to be relatable as human beings. So some of the inventors, some of my favorite that I went to were the Wright brothers, with the 1903 flyer that is the first human flight under its own power. The Samuel Morse. Samuel Morse is interesting to me because he is both the inventor of the telegraph, who used his patents to protect his ability to commercialize it and to expand the markets across the regions of the United States for commercial use. So he had a profound impact. The other thing I like about Morse is he also was an artist.
Yeah.
He was a portrait painter, and he gave a series of lectures at one point when he was the president of a National Academy of Art or of some sort, and in one of those it was a theology of art or design, something like that. But it was him applying he was a devout Christian. It was him applying his faith in his works, and that really speaks to me. And the one quote I remember from him is Morse said that science and art are not at odds. He understood that God had both those things created, and they're not at odds, that they're of the same creation and the same creator. So
aren't some of the paintings inside the Capitol building from him?
I believe so, yes. And it's interesting in the rotunda of the Capitol. There's a painting at the very top of the dome on the inside of the Capitol, and it's the apotheosis of George Washington. Mm-hmm. So it's clouds and George Washington sitting in heaven with these, figures around him and stuff. But also in that painting here is also Samuel Morse.
Yeah. Right. So people forget. So there was, at least in the 1800s, inventors were celebrated.
Yes.
Morse, Edison, Bell, etc., and quite a few others. Yeah. So in the Capitol, they painted Morse and George Washington. I mean, really, the concept of innovation was so important to the United States.
And George Washington too was a real proponent of inventors and invention and entrepreneurship around that. He was remarkable as a leader, having the foresight to really drive that, to bring it about. Other inventors in there are...
before you leave, Samuel Morse, so Morse was 1830s or something like that. Don't quote me exactly.
30s, 40s, 50s.
Right. So he comes up with the telegraph concepts. He gets patents on it. By the way, they're litigated to this day. Some of the Morse cases get cited in patent litigation. But what was his first test? What did he transmit?
The first message was, "What hath God wrought?"
Mm-hmm. Which comes from
I want to
remember?
say Jeremiah, but I may probably
Okay.
wrong. It may be Ecclesiastes, but I don't remember.
Yeah, he obviously was a religious man, and he did recognize the conjunction of those issues. Okay, so
Can I name a couple more?
Yeah, please.
One is Robert Cade, James Robert Cade, who invented Gatorade. Now that pains me as a Georgia Bulldog alum to have to say something nice about anything to do with the University of Florida, but I do it because I'm impressed by Gatorade. I'm impressed by the inventor and the invention and just how it came about. And you'll have to read the book to get the story. To invent is divine. But Dr. Cade was someone who now there's a museum his children have opened in Gainesville that tells the Gatorade story. So it's a remarkable tale. And then there's a friend of mine, John McCorkle. He's well known, globally in his corner of electronics.
Mm-hmm.
And he is a remarkable engineer, owns, I think, 90 patents now. But he's a friend and a Christian. We're in a Bible study together. And I asked him in interviewing, I did several interviews of creators and inventors that are represented in the book, and some from those interviews. And John, I said, what's it like to be, as a Christian, to be an inventor? And he said, oh, it's great. And he went on to tell about how God provides, and when he's facing a problem and he's looking for a solution or a method or a concept to apply or something toward getting the solution, something will come before him that he had not. He might hear it at a talk at a conference or something, or he may run across an article or something that has just what he needs at that point to spur the next thought. So there's Susie Armstrong from Qualcomm, who is the brilliant inventor who made possible the connection of our cell phones with the internet. Mm-hmm. That's how we can do all the internet searches on our phones these days. It's Susie Armstrong.
Well, you have so many stories in the book. Just for that alone, it's worth a read. But in the last few minutes, I want to come around to the current state of the intellectual property system, and in particular the patent system. Because, by the way, I find it fascinating that in your book that, it's, let's say, 275 pages or something like that.
Somewhere around there.
It's 270 pages or so. You manage to go from the Garden of Eden, Genesis, and all the way through the U.S. Constitution and the various inventors in the modern era to the most recent patent bill, the Restore Act, and so the Constitution says that if you're going to have a patent and copyright system, it should give exclusive rights, but which means that the owner can exclude the others who might infringe, keep them out for a limited period of time, but in about 2006, the Supreme Court issued a decision called in an eBay case, and said that these exclusive rights can be enforced by non-exclusive means. And since then, it's been very difficult to get an injunction in many cases and keep infringers out. There's a bill that's pending now. It's bipartisan, bicameral, called the Restore Act, that would address this. How do you tie all of that, to in your book, and to Invent is Divine, and how do you tie that to Genesis and the biblical pronouncements here on creativity and ownership?
Well, the eBay versus Merck Exchange ruling was exactly opposite to all the Bible has to say about creativity, ownership being connected because of inherent rights of creativity and ownership. It divides, it diminishes your rights that you should be able to have and to claim and enforce, just because you are a human being with those inalienable rights. But they're being alienated thanks to the Supreme Court and the lower court's implementations of that. So the Restore Patent Rights Act is the one that would rectify that by returning to what for 200 years was the legal standard, and that is, if your patent is valid, found and affirmed in court to be valid, if it is proven in court to be infringed, there's one remedy that accomplishes exclusivity, the right to exclude others. That is injunction. And if you don't have access to an injunction once you've proven validity and infringement, it's an incomplete, there's a hole in your rights, legally speaking.
In fact, it's difficult to understand what ownership really means without the right to exclude. It's really hard to say you own your house if you cannot lock the front door and anybody can come in, even if they're willing to pay rent. You might not want a roommate in your house. To personal property rights, you have an automobile or you wear a watch. You might not want to let others just take it because they want to. The right to exclude is one of the most fundamental tenets of ownership.
Yes.
And without it, you don't really have ownership.
And the galling part about it to me is that in all other forms of property, injunction's perfectly safe. It hasn't been diminished as it has with patents. Furthermore, the right to injunctive relief remains for all other forms of intellectual property. Patents are the only one where injunction is now inhibited. That is senseless.
And again, your ability to tie that in your book, To Invent is Divine, to tie that to the foundational principles of this country and then the biblical pronouncements all the way through is remarkable. It's a great read, and I really enjoyed the conversation. Jim Edwards, thank you very much.
Andrei, thank you. I appreciate it.